Tonight, lots of big news about the Supreme Court. If you thought we had certain givens, you may want to think again. We could be seeing an assault on precedent from conservative justices that could have huge implications for a number of important issues, including Roe v. Wade. The Washington Post's Supreme Court reporter will be joining us in just 2 minutes. Then, the Varsity Blues case back in the news. Our legal panel will join us to hash out the latest developments involving both Felicity Huffman and Lori Loughlin. And we'll also head to Capitol Hill to take a look at the latest on Trump's tariffs and how they're causing huge headaches for a bunch of Republicans. Good evening and welcome to RFL. I'm Richard French. We're going to start tonight at the Supreme Court. Usually a case involving something called sovereign immunity wouldn't get lead attention in the program, but in this case, it could be a game changer and also a harbinger of things to come. Conservatives on the high court just overturned 5-4 a 40-year-old precedent. Clarence Thomas, he wrote the majority decision. Justice Stephen Breyer, he wrote this in dissent, and I'm going to quote a portion of it. It's dangerous to overrule a decision only because 5 members of a later court come to agree with earlier dissenters on a difficult legal question. Today's decision can only cause one to wonder which cases the court will overrule next. Now, this ruling could have huge implications on many fronts that includes abortion. And that brings us to Alabama. Lawmakers there just passed a bill that bans nearly all abortions. Republican Governor Kay Ivey, she's expected to sign it. It does not include exceptions for rape or incest, but does have a single exception for cases where the mother's life is at risk. And doctors who even attempt to perform the procedure could face jail for life. Now, the lawmaker who sponsored the bill said that the intention is clear. This is a mechanism to get all the way to the Supreme Court to challenge Roe v. Wade. Take a listen.
The bill is meant to address Roe versus Wade and the issue that decision was made on, which was, is the baby in the womb a person? I believe that the baby in the womb is a person.
So the intention here was naked. This was not about Alabama. This was about challenging Roe v. Wade. And joining us now to discuss, Washington Post Supreme Court reporter Robert Barnes. So, Robert, traditionally, the High Court is loath to upend precedent, and they'll move in a gradual pace. But Breyer's warning there was really clear that his worry is that there'll be a more casual approach here to upending precedent. And he even listed, obviously, Roe being at the top of the list, but other concerns as well. Do you think Breyer's worries are well-founded given the current makeup of the court?
Well, the court overturns precedent, a little more regularly than they would like to acknowledge. They do it probably 2 or 3 times a term, but usually they're not very big ones, or when they overturn a huge case, it gets a lot of attention. To overturn something as iconic as Roe v. Wade, which was decided so many decades ago, would be a huge deal for the court and would really be a change that would get a lot of people's attention. I think that Justice Breyer, he didn't mention Roe, but I think he's certainly thinking about those and other cases that have been decided maybe in a fashion that this new conservative majority wouldn't like.
And among them, affirmative action, et cetera. But I want to remind people, not too long ago, what now Justices Neil Gorsuch and also Mr. Kavanaugh said in their confirmation hearings when they were pressed directly on Roe and the precedent thereof.
Do you view Roe as having super precedent?
Well, Senator, a super precedent is
in numbers, 44.
It has been reaffirmed many times. I can say that, yes.
What would you say your position today is on a woman's right to choose?
It is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent.
So they were pretty clear. They avoided a lot of questions. They didn't avoid that one. They made it clear that they viewed it as settled law. The president, conversely, Robert, as you know, he promised everybody in his base that he was going to put 2 people on the court here that would be a solid yes vote when it came to overturning Roe, and he would change the law of the land if it came to them. certainly looks like Alabama is on a collision course for the high court. What do you think at the end of the day? Should we take what they said at confirmation hearings as gospel, or do they say just basically what we wanted to hear?
Well, saying something is settled law is a little different from saying if you have the chance to overturn that law, will you do it? And that's a kind of question that a Supreme Court nominee is never going to answer, whether it's a liberal nominee or a conservative nominee. I will say that the court likes to move gradually, and the court doesn't have to overturn Roe v. Wade in order to approve a lot of restrictions on abortion that the states have been passing for a number of years now. The truth is that there are a number of restrictions in some states. There are a number of guarantees of abortion in other states. And it's not sort of a one or the other thing. You don't have to overturn Roe to approve some of the things that the conservative states want to do on the subject.
I'm curious, Robert, when justices look at this case, what factors they consider, in that I saw a recent poll that a third of Americans think that Roe should either be overturned or is too broadly applied. 2/3 of the Americans say that it's fine the way it is, and others that would like to see it expanded even further. Public sentiment, and then also the method in which it would get to the court. We just played the soundbite from Alabama where the originator of this legislation said, no, we didn't even consider fetal heartbeat. We intentionally crafted this legislation so the Supreme Court would have a chance to throw out Roe v. Wade. Does the High Court care about how it got there, the case, and also how the public feels about the issue?
Well, I mean, I'm sure the justices read the newspapers and public polls the way the rest of us do. I think they're aware of public opinion. I don't think it particularly factors into something like this. The justices make unpopular decisions all the time. As far as getting there as a test, remember that the court doesn't have to take every case that comes to it. If lower courts strike down this law, saying that it is clearly unconstitutional based on precedent and settled law at the time, then it would surely be appealed to the Supreme Court, but the Supreme Court doesn't have to take the case if it doesn't want to.
Robert, I appreciate the time. Thank you so much.
My pleasure. Thanks for having me.
All right, everybody, we're going to take a quick break. But on the other side of the break, I'm going to bring in the guys, our legal panel, and we're going to take a look at several stories. But we're going to start with wrongful convictions and what we can learn from them. Can they help make things right for future cases? And we've got a couple high-profile ones in the news right now, and a movie coming down the pike that reminds us of, well, let's say, an unsettling time in New York City.